So in the previous episode of the podcast, I said that we would continue on through the Supreme Court's 2024 term opinions in this episode, but the Supreme Court has since issued a number of opinions from the 2025 term, so I lied. We are going to be reading a decision from the 2025 term in this episode. So, in episode 17 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Bowe versus United States. The case was decided January 9th, 2026. And as always, we'll start with the syllabus. Petitioner Michael S. Bowe is serving a 24-year sentence in federal custody after pleading guilty in 2008 to 3 offenses. 1. Conspiracy to commit Hobbs Act robbery. 2. Attempted Hobbs Act robbery. And 3. Using a firearm in relation to a crime of violence as defined in 18 U.S.C. Section 924C1A. Bowe's Section 924C conviction carried a mandatory 10-year sentence to be served consecutively to his sentence for the robbery offenses. To have been properly convicted under Section 924C, at least one of Bowe's other offenses must qualify as a crime of violence under one of 2 definitional clauses in Section 924C, the Elements Clause, Section 924C3A, or the Residual Clause, Section 924C3B. But decisions issued years after Bowe's conviction call into question whether either clause can support his Section 924C conviction. This case concerns Bowe's efforts to obtain post-conviction relief from the mandatory consecutive 10-year sentence imposed under Section 924C. A comprehensive statutory scheme governs when and how state and federal prisoners can seek post-conviction relief in federal court. See 28 U.S.C. Section 2254, state prisoners, Section 2255, federal prisoners. Particularly relevant here, under the Anti-Terrorism and Effective Death Penalty Act of 1996, AEDPA, second or subsequent efforts at obtaining post-conviction relief require the prisoner first to seek certification from a court of appeals that the filing meets threshold conditions before a prisoner can proceed in a district court. While Section 2244 and 2255H have distinct requirements, Section 2255H cross-references some of the procedures in Section 2244 for how a panel of the appropriate Court of Appeals certifies a second or successive filing. Bowe first sought Section 2255 relief in 2016, arguing that Section 924C's residual clause was unconstitutional. The district court denied the motion, reasoning that, regardless of the residual clause's constitutionality, Bowe's Section 924C conviction was proper because attempted Hobbs Act robbery qualified as a crime of violence under the Elements Clause. In 2019, after Davis, Bowe sought permission from the 11th Circuit under Section 2255H to file a second or successive motion. A 3-judge panel found that Bowe did not meet Section 2255H's threshold conditions. Although the panel acknowledged that Davis announced a new retroactive constitutional rule, one of the 2 statutory gateways for successive motions under Section 2255H2, it held that Bowe could not make a prima facie showing that his Section 924C conviction was unconstitutional because then binding circuit precedent still treated attempted Hobbs Act robbery as a crime of violence under the Elements Clause. After Taylor was decided in 2022, Bowe once again sought authorization under Section 2255H, arguing that Davis and Taylor leave none of his convictions as a valid predicate crime of violence under Section 924C. A panel dismissed the part of Bowe's request resting on Davis, reasoning that the claim had been presented in a prior application and that the panel lacked jurisdiction over such old claims under Section 2244b1. The panel also denied the part of Bowe's request that rested on Taylor, concluding that Taylor did not announce a new constitutional rule within the meaning of Section 2255H2. Bowe returned to the 11th Circuit several times seeking authorization to pursue post-conviction relief, initial hearing en banc, and reversal of circuit precedent applying 2244b1's old claim bar to federal prisoners' successive 2255 motions. He also requested certification of the question whether Section 2244b1 applies to federal prisoners. Bowe's requests were denied. Bowe eventually filed this petition for certiorari, pointing out a circuit split. 6 circuits apply Section 2244b1's old claim bar to federal prisoners, while 3 do not. The court granted review. Held. Part 1. The court has jurisdiction because Section 2244b3e does not bar this court's review of a federal prisoner's request to file a second or successive Section 2255 motion. Section A. Section 2244b3e provides that the denial of authorization to file a second or successive application shall not be the subject of a certiorari petition. That provision does not apply to federal prisoners. It is housed within Section 2244, which imposes several strict requirements that apply only to state prisoners. It also speaks only to second or successive application. But unlike state prisoners who file such applications, federal prisoners file motions. Section B. The government contends that Section 2255H's cross-reference to Section 2244, providing that a successive motion must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals to contain the content requirements in Section 2255H, also imports Section 2244's certiorari bar. But Section 2255H's cross-reference, coupled with its context, does not provide the clear indication needed to strip this court of jurisdiction. Given the broad grant of certiorari jurisdiction to the court, Congress must speak clearly if it seeks to impose exceptions to that jurisdiction. In Castro v. United States, a case also brought by a federal prisoner, the court held that Section 2244b3e posed no bar to its review, explaining that the government's reading would close the court's doors to a class of habeas petitioners without any clear indication that Congress intended such a result. The same clear indication necessary in Castro to strip the court of jurisdiction is required here. The Section 2244b3e issue arises in the same context, and the government argues that the very same provision bars the court's review in this case. This clear indication is not a magic words requirement. It simply asks whether text and structure unambiguously show that Congress intended to prevent the court's exercise of its certiorari jurisdiction. A provision that can reasonably be read more than one way in context is not sufficiently clear. Section 2255H's cross-reference does not provide the clear indication of intent required to strip the court of jurisdiction. The language of the cross-reference is both narrow and specific. It says that a second or successive Section 2255 motion must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals to contain one of the 2 threshold content requirements. It incorporates only the provisions in Section 2254 that provide for how a panel of the appropriate Court of Appeals certifies a second or successive filing, and directs that those procedures be used to evaluate whether the filing contains the content requirements listed in Section 2255H. Section 2244b3e is not one of those provisions, and it has nothing to do with the content requirements in Section 2255H. For these reasons and others, whether Section 2244b3e's certiorari bar falls within the scope of Section 2255H's cross-reference is at most ambiguous. Ambiguous language cannot provide the required clear indication, and the government's remaining arguments do not supply the necessary clarity that the text lacks. The government also suggests that it would make little sense to bar certiorari review of authorization decisions concerning state prisoners but not federal ones. That argument carries little weight when the governing standard requires Congress to speak clearly. Moreover, Congress treated state and federal prisoners differently across AEDPA, with state prisoners often facing higher hurdles to relief. Allowing further review in this court is thus consistent with both AEDPA's purposes and practical considerations. Part 2. Section 2244b1 does not apply to second or successive motions filed under Section 2255H by federal prisoners challenging their convictions or sentences. Section A. The text of Section 2244b1's old claim bar states that a claim presented in a second or successive habeas corpus application under Section 2254 that was presented in a prior application shall be dismissed. State prisoners alone file habeas corpus applications under Section 2254. That specific reference to Section 2254 was deliberate. Elsewhere in this very section, Congress expressly distinguishes Section 2254 applications from Section 2255 motions. When interpreting statutes, the court presumes that differences in language like this convey differences in meaning. By its plain terms, Section 2244b1's old claim bar applies only to state prisoners. Section B. Section 2255H's cross-reference to Section 2244 does not make Section 2244b1 applicable to federal prisoners' successive Section 2255 motions. Amicus contends that Section 2255H incorporates Section 2244, including Section 2244b3c, which requires a panel to determine that the application makes a prima facie showing that it satisfies the requirements of this subsection. From here, one of the requirements of subsection B is Section 2244b1. Accordingly, amicus argues, following this chain of cross-references leads to the conclusion that Section 2244b1 must apply to federal prisoners. But that position is erroneous under the same reasoning that explains why the court has jurisdiction. Section 2255H's cross-reference incorporates the procedures in Section 2244 only as they relate to how a panel certifies a second or successive filing. At bottom, the best textual reading of both Section 2255H and Section 2244B is that when a federal prisoner moves for authorization, a panel can authorize the filing if the filing makes a prima facie showing that it satisfies one of the two grounds in Section 2255H, the two and only two conditions in which a second or successive Section 2255 motion may proceed. The argument that Congress meant for AEDPA to treat second or successive filings by federal and state prisoners the same fails. AEDPA is replete with examples of Congress treating state and federal prisoners differently, including in the context of limitations on second or successive filings. Any concern associated with Congress allowing old claim litigation for federal prisoners is overstated, given that all claims, even the repeated ones, must meet the strictly limited threshold requirements of Section 2255H, and should they survive that review, they must still conform with the demanding statute of limitations contained in Section 2255F. Very few claims will satisfy either, let alone both. The court leaves it to the 11th Circuit to determine in the first instance whether Bowe should receive authorization to file a second or successive motion under the correct standard. Justice Sotomayor delivered the opinion of the court, in which Chief Justice Roberts and Justices Kagan, Kavanaugh, and Jackson joined. Congress has created a comprehensive scheme to address when and how state and federal prisoners can seek post-conviction relief in federal courts. A state prisoner can file an application for a writ of habeas corpus under 28 U.S.C. Section 2254. A federal prisoner, by contrast, can file a motion to vacate, set aside, or correct a sentence under Section 2255. Each provision contains its own procedural and substantive requirements that an individual must satisfy. This case concerns the more complicated situation when a prisoner returns to federal court after a prior attempt for relief has failed. In this situation, Congress has enlisted the courts of appeals to play a gatekeeping role in the consideration of second or successive filings brought by federal and state prisoners. Under this system, before a prisoner can bring such a filing in a district court, a court of appeals must certify that the filing meets certain threshold conditions. Section 2244 governs authorization requests made by state prisoners, and Section 2255H, in turn, governs requests made by federal prisoners. The two have distinct requirements, but through a limited cross-reference in Section 2255H to Section 2244 for how a filing is certified by a panel, Congress has borrowed certain of the procedures that apply to state prisoners and applies them to federal prisoners too. This case presents two questions regarding which aspects of Section 2244 fall within the scope of Section 2255H's cross-reference. The first is whether Section 2244B3E, which prohibits the denial of an authorization by a court of appeals to file a second or successive application from being the subject of a petition for a writ of certiorari, bars this court's review of authorization decisions concerning the motions of federal prisoners. If it does, this court would lack jurisdiction to hear this case. The court holds that it does not. In the narrow cross-reference to the procedures in Section 2244, Congress has not clearly indicated that it intended to incorporate Section 2244B3E's certiorari bar. The second question is whether Section 2244B1, which directs courts to dismiss a claim presented in a second or successive habeas corpus application under Section 2254 that was presented in a prior application, applies to motions filed by federal prisoners. It does not. Section 2244B1, by its express terms, applies only to state prisoners' habeas applications under Section 2254, not to federal prisoners' motions under Section 2255. Part 1. Petitioner Michael S. Bowe is in federal custody. In 2008, he pleaded guilty to 3 offenses. 1. Conspiracy to commit Hobbs Act robbery, 18 U.S.C. Section 1951A. 2. Attempt to commit Hobbs Act robbery. And 3. The use, carrying, brandishing, or discharge of a firearm in relation to a crime of violence, Section 924C1A. Bowe received a 24-year sentence. 10 of those years were imposed because of the Section 924C conviction, which carried a mandatory 10-year sentence consecutive to the sentence for the predicate robbery offenses. Bowe did not appeal. In the decade since, this court has issued several decisions that have called Bowe's Section 924C conviction into question. To appreciate the implications of those decisions, it is important first to understand how Section 924C operates. Section 924C applies if, as relevant here, an individual commits a qualifying crime of violence with a firearm. A crime of violence, in turn, is defined in 2 ways. Under the Elements Clause, it is a felony that has as an element the use, attempted use, or threatened use of physical force against the person or property of another. Under the Residual Clause, it is a felony that, by its nature, involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. For Bowe to have been properly convicted under Section 924C, and thus to have received the accompanying 10-year consecutive sentence, his conviction for either conspiracy or attempt to commit Hobbs Act robbery must qualify as a crime of violence under either the Elements or Residual Clause. Today, it is likely that neither clause would permissibly support Bowe's Section 924C conviction. In United States v. Davis, this court held that the residual clause is unconstitutionally vague. In United States v. Taylor, the court held that attempted Hobbs Act robbery does not qualify as a crime of violence under the Elements Clause. 11th Circuit precedent is also clear that conspiracy to commit Hobbs Act robbery does not satisfy the Elements Clause. If sentenced today, therefore, Bowe likely would not be subject to the 10-year mandatory consecutive sentence that he is now serving. Nevertheless, the timing of this court's decisions, coupled with the timing of Bowe's efforts to take advantage of them, have produced procedural complications that have so far prevented relief leading to this appeal. Bowe, acting pro se, initially sought post-conviction relief under Section 2255 in 2016 before the court decided Davis, arguing that the residual clause is unconstitutionally vague. A district court rejected Bowe's claim in part because regardless of the residual clause's constitutionality, attempted Hobbs Act robbery qualified as a crime of violence under Section 924C's Elements Clause. After Davis was decided in 2019, Bowe sought permission from the 11th Circuit to file a second or successive motion. A 3-judge panel declined to authorize Bowe's motion. Although the panel acknowledged that Davis had announced a new retroactive rule of constitutional law, which is one of 2 grounds on which a second or successive motion can proceed, It held that Bowe could not make a prima facie showing that his Section 924C conviction and sentence were unconstitutional because under then prevailing 11th Circuit precedent, attempted Hobbs Act robbery still qualified as a crime of violence under the Elements Clause. Then, after Taylor was decided in 2022, Bowe once again sought permission from the 11th Circuit to file a second or successive motion. This time, Bowe argued that under Davis and Taylor, none of his convictions qualified as a predicate crime of violence. A three-judge panel dismissed the part of Bowe's request that rested on Davis, reasoning that because the claim was presented in a prior application to file a second or successive motion, the panel lacked jurisdiction over it under Section 2244b1. The panel also denied the part of Bowe's request that rested on Taylor, concluding that Taylor did not announce a new constitutional rule as needed to secure relief under Section 2255H2. Bowe did not stop there. A few months later, he again sought authorization to file a second or successive motion, again relying on Davis and Taylor. This time, Bowe also moved for initial hearing en banc. As relevant, he asked the 11th Circuit to overturn its precedent holding that Section 2244b1's old claim bar applies to federal prisoners' successive Section 2255 motions. In Bowe's view, that bar applies only to state prisoners, not federal prisoners like him. A three-judge panel dismissed Bowe's request for authorization, citing Section 2244b1, and the 11th Circuit denied Bowe's motion for initial hearing en banc. Bowe then moved for an original writ of habeas corpus in this court. It was denied. Bowe returned to the 11th Circuit seeking authorization, initial hearing en banc, and certification of the question whether Section 2244b1 applies to federal prisoners. As before, a three-judge panel dismissed Bowe's request for authorization relying on Section 2244b1. The panel also declined to certify the question Bowe presented, and the full 11th Circuit denied his motion for initial hearing en banc. Finally, Bowe filed a petition for a writ of certiorari. The 11th Circuit is one of 6 circuits that apply Section 2244b1's old claim bar to federal prisoners. 3 circuits do not. Footnote 1. This is just a citation to several circuit court opinions that demonstrate the circuit split, so I'm not going to read them all out. Carrying on. The court granted certiorari to resolve the issue. Part 2. As a threshold matter, the government argues that the court cannot resolve the circuit split concerning Section 2244b1's old claim bar because the court lacks jurisdiction to hear the case under Section 2244b3e. That provision states that the denial of an authorization by a court of appeals to file a second or successive application shall not be the subject of a petition for a writ of certiorari. If Bowe were in state custody, then the government would be correct. He is not. Section 2244b3e does not prevent the court's review because the certiorari bar does not clearly apply to motions filed by federal prisoners like Bowe. Section A. In the Anti-Terrorism and Effective Death Penalty Act of 1996, Congress established a gatekeeping mechanism for the consideration of second or successive filings in the federal courts. The associated procedural and substantive requirements are stringent. State prisoners looking to file a second or successive application must comply with Section 2244b, which provides in relevant part, quote, "Before a second or successive application permitted by this section is filed in the district court, the applicant shall move in the appropriate court of appeals for an order authorizing the district court to consider the application. A motion in the Court of Appeals for an order authorizing the district court to consider a second or successive application shall be determined by a three-judge panel of the Court of Appeals. The Court of Appeals may authorize the filing of a second or successive application only if it determines that the application makes a prima facie showing that the application satisfies the requirements of this subsection. The Court of Appeals shall grant or deny the authorization to file a second or successive application not later than 30 days after the filing of this motion. The grant or denial of an authorization by a Court of Appeals to file a second or successive application shall not be appealable and shall not be the subject of a petition for rehearing or for a writ of certiorari. A district court shall dismiss any claim presented in a second or successive application that the Court of Appeals has authorized to be filed unless the applicant shows that the claim satisfies the requirements of this section. End quote. By comparison, a federal prisoner seeking to file a second or successive motion must satisfy Section 2255H. That provision states in full, quote, "A second or successive motion must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals to contain 1. Newly discovered evidence that if proven and viewed in light of the evidence as a whole would be sufficient to establish by clear and convincing evidence that no reasonable fact finder would have found the movant guilty of the offense, or 2. A new rule of constitutional law made retroactive to cases on collateral review by the Supreme Court that was previously unavailable." End quote. Unlike the provisions governing authorization decisions for state prisoners, Section 2255H does not mention this court's certiorari jurisdiction, let alone purport to limit it, nor does Section 2244B3E readily apply to federal prisoners on its face. Section 2244 overall imposes several strict requirements that apply only to state prisoners with the aim of facilitating finality, and the certiorari bar in particular speaks to second or successive applications which federal prisoners do not file. Footnote 2. This is just a citation to Section 2254 provisions that apply exclusively to state prisoners, so I'm not going to read them all out. Carrying on. Whether the court has jurisdiction therefore turns on the scope of Section 2255H's cross-reference to Section 2244. In the government's view, the cross-reference captures all of Section 2244B3 and B4, including the certiorari bar in Section 2244B3E. Although the government is correct that the cross-reference incorporates some of the provisions it identifies, the government is wrong that it also incorporates the certiorari bar. That is because the cross-reference, coupled with its context, does not provide the clear indication needed to strip this court of jurisdiction. Section B, subsection 1. This court has certiorari jurisdiction over any case in the courts of appeals upon the petition of any party to any civil or criminal case before or after rendition of judgment or decree. Given that broad grant of jurisdiction, Congress must speak clearly if it seeks to impose exceptions to that jurisdiction. In Castro v. United States, Castro, a federal prisoner, filed a motion for post-conviction relief in federal district court. He had previously filed a motion pro se attacking his conviction, but he had not specifically labeled it as a Section 2255 motion. The district court construed Castro's previous filing as his first Section 2255 motion and the second filing before it as a second Section 2255 motion. Because Castro did not receive authorization from the Court of Appeals before filing the second motion, the court dismissed it. The court, however, granted Castro a certificate of appealability as to its determination that the motion was his second one. The Court of Appeals later affirmed the dismissal. This court granted certiorari to address the recharacterization of Castro's first filing. The court also asked the parties whether Section 2244B3E barred its review. Like here, the government argued that it did. In the government's view, the Court of Appeals had denied Castro authorization when it affirmed the district court's dismissal, making that denial the subject of his petition for certiorari for the purposes of Section 2244B3E. This court accepted that characterization of the proceedings below for the sake of argument, yet disagreed that Section 2244B3E posed a bar to its review. That was because the subject of Castro's petition was not the denial of authorization, but rather the lower court's refusal to recognize that the Section 2255 motion was his first, not his second. Footnote 3. The government stresses, and the dissent echoes, that the Castro court took as a given that Section 2244B3E applies to federal prisoners by concluding that it had jurisdiction because the subject of the certiorari petition fell outside of the provision's scope, not because the provision applied to state prisoners alone. As the government elsewhere acknowledges, however, the court did not address the threshold question whether Section 2244b3e applies to federal prisoners. Thus, at most, the court assumed for the sake of its analysis that Section 2244b3e applied. That assumption is not a holding to which this court is now bound. Carrying on. As relevant here, the court stressed a fatal flaw with the government's argument, as it explained reading the statute as the government suggested to bar jurisdiction in that case would close our doors to a class of habeas petitioners seeking review without any clear indication that such was Congress's intent. That conclusion was also difficult to reconcile with the basic principle that we read limitations on our jurisdiction to review narrowly. Footnote 4. The dissent's rendition of Castro is mistaken. It suggests that the clear indication requirement was tied to the troublesome result that under the government's interpretation, a prisoner could not appeal a panel decision characterizing a filing as his first, not his second, even though the court had previously allowed the government to appeal a decision reaching the opposite result. That was one troubling result of the government's position, but Castro also listed two more troubling results: the closing of our doors to a class of habeas petitioners seeking review without any clear indication that was Congress's intent, and the difficulty in reconciling that outcome with the basic principle that we read limitations on our jurisdiction to review narrowly. The latter two concerns arise here, and thus Castro requires a clear indication before we will close our doors to this distinct class of prisoners seeking habeas relief. Carrying on. Because a clear indication was necessary in Castro to strip the court of jurisdiction, a clear indication is required here. The issue arises in the same context, and the government argues that the very same provision bars the court's review in this case. This clear indication, importantly, is not a so-called magic words requirement. It simply asks whether the text and structure support the unambiguous understanding that Congress intended to prevent this court's exercise of its certiorari jurisdiction. If a provision can reasonably be read multiple ways given its content and context, it is not sufficiently clear. The dissent contends that this clear indication requirement comes from thin air. As just explained, however, it comes from Castro itself. It also draws support from this court's historical practice of declining to read ambiguous statutes to limit its certiorari jurisdiction, which even the dissent acknowledges. The dissent also argues that this clear indication requirement must be mistaken because it is not derived from principles of constitutional avoidance. Constitutional avoidance, however, is not the only possible source of a rule like Castro's. This court also has required Congress to speak clearly in other contexts when Congress wishes to do something that the Constitution allows. For example, the court will interpret a procedural requirement as jurisdictional only if Congress clearly states that it is. In that context, Congress need not incant magic words, but the traditional tools of statutory construction must plainly show that Congress imbued a procedural bar with jurisdictional consequences. Requiring this showing is driven by the harsh consequences of finding a procedural requirement jurisdictional, even though Congress, of course, maintains the power to impose such consequences. A similar logic drives the clarity requirement here when reading Section 2255H as the government and the dissent do would close our doors to a class of habeas petitioners. Footnote 5. No one contends that Bockler controls this case. The Bockler line of cases simply demonstrates that this court requires clarity in some contexts, even absent constitutional concerns, undermining any suggestion that constitutional avoidance is the only permissible source of Castro's rule or other interpretive rules like it. Nor does this line of cases stand alone. Carrying on. Subsection 2. Section 2255H's cross-reference does not provide the clear indication required to bar this court's review. The language of the cross-reference is both narrow and specific. It says that a second or successive Section 2255 motion must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals to contain one of two threshold content requirements. The text of the cross-reference does not end at certified as provided in Section 2244 as the dissent would have it. The cross-reference thus appears to incorporate only the provisions in Section 2244 that provide for how a panel of the appropriate Court of Appeals certifies a second or successive filing and directs that those procedures should be used to evaluate whether the filing contains the content requirements listed in Section 2255H. Section 2244b3e is not one of those provisions, and it has nothing to do with the content requirements of Section 2255H. First, the cross-reference speaks to how a panel of the Court of Appeals certifies a filing. But this court is not a panel of the appropriate Court of Appeals, so the cross-reference does not speak to this court's jurisdiction. Second, this court's review or lack thereof is not part of how a panel certifies a second or successive filing. Section 2244b3a identifies that the filing must be certified in the Court of Appeals before an individual can proceed in the district court. Section 2244b3b requires that a three-judge panel make the certification decision. Section 2244b3c tells the panel that the filing must make a prima facie showing that it satisfies the relevant gatekeeping requirements. Finally, Section 2244b3d instructs the panel to decide whether to certify a filing within 30 days of receiving the request. These provisions all describe the procedures that a panel must follow in certifying a second or successive filing and are therefore incorporated by Section 2255H's cross-reference. In stark contrast, the certiorari bar in Section 2244b3e says nothing about how the Section 2255 motion must be certified. It instead speaks to what happens after a panel has acted on a certification request, specifically whether an individual can appeal the panel's certification decision. If the certiorari bar did not exist, no aspect of how the panel certifies a filing would change. Footnote 6. The dissent asks what would be the point of subparagraph B without the certiorari bar in subparagraph E. The point of B is still apparent. It identifies who makes the authorization determination in the first instance, a three-judge panel of the Court of Appeals. Carrying on. Put simply, the certiorari bar addresses an entirely different act, filing a certiorari petition, not certifying a successive motion, by an entirely different actor, the prisoner, not the panel, in an entirely different court, this court, not the Court of Appeals. If Congress intended Section 2255H to incorporate this post-certification orange alongside all the panel certification apples in Section 2244b3, it did not say so clearly. Of course, as the government and the dissent point out, barring appeals of certification decisions has an effect on the panel's decision by making it conclusive. That effect, however, has little to do with how the motion is certified by a panel. Section 2255H's reference to how the motion must be certified under Section 2244 thus does not incorporate Section 2244b3e's post-certification bar in the clear manner that Castro requires. Contrary to the dissent's framing, Hone v. United States does not support a different conclusion. That case concerned whether the court had jurisdiction over a decision by a three-judge panel to deny a prisoner a certificate of appealability under Section 2253C, and held that the court does not have such jurisdiction. Section 2253C applies to federal and state prisoners, and dictates that before an individual can appeal from a district court's denial of a habeas petition, he must secure permission from a circuit justice or judge. Court-appointed amicus in Hone argued that the decision denying permission was not a case in the Court of Appeals for the purposes of this court's jurisdiction under Section 1254(1). The court rejected that construction, however, in part because it would have rendered Section 2244b3e, which the court suggested was a requirement for state prisoners filing second or successive habeas applications under Section 2254, as superfluous. That was because all the reasons amicus gave for why a decision denying a certificate of appealability did not constitute a case for the purposes of Section 1254(1 would equally have applied to a decision denying authorization to bring a second or successive filing. The court nowhere held that Section 2244b3e applied to federal prisoners. That is not surprising because the case did not present that question. Nor does the court's holding today render Section 2254b3e superfluous, as all agree it bars this court's review of panel authorization decisions concerning motions to file second or successive applications by state prisoners. The dissent also relies on Hone to argue that it already stands for the proposition that Section 2244b3e imposes a clear limit on our jurisdiction in this case. Not so. No one disputes that the certiorari bar clearly deprives the court of jurisdiction over classes of cases to which it applies. What is not clear is whether, through the cross-reference in Section 2255H, Congress intended for that bar to extend to federal prisoners, a point Hone simply did not address. Section B. For these reasons, whether Section 2244b3e's certiorari bar falls within the scope of Section 2255H's cross-reference is at most ambiguous. Ambiguous language, however, cannot provide the required clear indication, and the government's and the dissent's remaining arguments do not supply the necessary clarity that the text lacks. To begin, the government contends that there is textual support in Section 2244b3e for the understanding that the certiorari bar applies to federal prisoners through the cross-reference. On this score, the government points to how Sections 2244b3a through e each use the term second or successive application instead of referring to Section 2254 specifically or state prisoners more generally. This stands in contrast to nearly all the other provisions in Section 2244. In the government's view, this textual variation means that Congress intended for Section 2255H's cross-reference to incorporate any provision in Section 2244 that uses the term second or successive application, and the breadth of the cross-reference therefore must be understood on those terms. If that were so, Section 2255H's cross-reference would also incorporate Section 2244b4. That provision directs district courts to review and dismiss any claim presented in a second or successive application that the Court of Appeals has authorized unless the applicant shows that the claim satisfies the requirements of Section 2244. Put differently, once a second or successive application is certified, Section 2244b4 tells a district court to double-check that application satisfies Section 2244, including its gatekeeping requirements. Section 2244b4, however, plainly falls outside the scope of Section 2255H's cross-reference because Section 2244b4 has nothing to do with how a filing is certified as provided in Section 2244 by a panel of the appropriate Court of Appeals. Thus, accepting the government's argument that Section 2255H's cross-reference should be understood to incorporate any provision in Section 2244 that uses second or successive application would essentially require interpreting Section 2255H to mean a federal prisoner's second or successive motion must conform to all provisions in Section 2244 that are not expressly limited to state prisoners. That, of course, is not what Section 2255H says. The government also points to part of Section 2244b3e that does speak to a panel of a Court of Appeals. Specifically, Section 2244b3e says that an authorization decision shall not be the subject of a petition for rehearing, thereby barring panel rehearing. According to the government, because Section 2244b3e speaks to the panel in some regard, Section 2255H must have intended to incorporate that provision in its entirety. The government is wrong, however, that the certiorari bar is incorporated in this way. Whether Section 2244b3e's panel rehearing bar applies to federal prisoners says little and certainly nothing clear about whether Congress intended Section 2244b3e's separate certiorari bar to extend to authorization decisions concerning federal prisoners. Using the former to incorporate the latter is the kind of jurisdiction stripping by implication that cannot suffice. Next, the government and the dissent argue that allowing appeals from a panel's certification decision to this court is inconsistent with Section 2244b3d. That provision, which all agree is covered by Section 2255H's cross-reference, imposes a 30-day clock on a panel's certification decision after a litigant seeks authorization, though most courts of appeals view that requirement as advisory. When an individual seeks certiorari, on the other hand, he has 90 days from the date of decision to file a petition in this court. The government suggests that the 30-day limit for panel review indicates that Congress wanted the certification decision to occur quickly, and that allowing prisoners to seek certiorari for an additional 90 days after the panel review concludes would thwart that intention. The government's argument is misguided. Nothing about the court's decision today undermines Section 2244b3d's timeline for the panel's authorization decision. Nor is this inference so compelling as to provide the needed clarity to cut off this court's jurisdiction. It is entirely plausible that Congress intended to require panels to move quickly while still preserving the prisoner's ability to seek further review in the rare case that warrants this court's attention. Panels will still have the tools needed, moreover, to facilitate that quick review under this court's interpretation of Section 2255H's cross-reference. Footnote 7. Nor does the court's decision today risk unduly opening the floodgates to frivolous appeals from authorization decisions concerning federal prisoners. Such appeals will be governed by the ordinary rules that prevent abuses of the court's certiorari docket in every other circumstance. If Congress thought it best to strip the court of jurisdiction to keep these appeals away from the court's docket nonetheless, it failed to convey that intent sufficiently. Carrying on. From here, the government resorts to another structural argument. The certiorari bar is found in Section 2244b3's fifth subparagraph. Everyone agrees that Section 2255H's cross-reference incorporates the preceding four paragraphs. The government maintains that it would be odd that Congress intended to incorporate four of those subparagraphs and not all five. If Congress had intended for all five to travel together, however, it did not say so explicitly. That would have been easy to do. Congress simply could have referenced Section 2244b3 specifically, rather than broadly referencing Section 2244 with a narrow cross-reference only specifying how a second or successive filing is certified by a panel. Congress did not. The language it used instead supports the understanding that the provisions the cross-reference incorporates turn on their substance, not where they sit in a list. As explained supra, the certiorari bar does not clearly fall within the scope of the cross-reference on its own terms. Finally, the government invokes a practical concern. The government suggests that it would make little sense to bar certiorari review of authorization decisions concerning state prisoners but not federal ones. That argument carries little weight when the governing standard requires Congress to speak clearly. It also misses the mark. Congress treated state and federal prisoners differently across AEDPA, with state prisoners often facing far higher hurdles to relief. To name a few examples, the statutory requirements for second or successive filings for federal and state prisoners are not identical. Compare sections 2244b1 through 2 with sections 2255h 1 through 2. Indeed, the requirements for federal prisoners are more lenient, as explained in detail below. Further, for state prisoners alone, Congress requires exhaustion, and then, once in federal court, mandates deference to both the state court's application of federal law and its factual determinations. This differential treatment exists for good reason. Congress enacted AEDPA to further the principles of comity, finality, and federalism. The Act recognizes a foundational principle of our federal system. State courts are adequate forums for the vindication of federal rights. Out of respect for state courts and their ability to adjudicate claims of constitutional wrong, AEDPA erected a formidable barrier to federal habeas relief for state prisoners. Federal courts will not lightly conclude that a state's criminal justice system has experienced the extreme malfunction for which federal habeas relief is the remedy. Comity and federalism, however, fall away when a federal court reviews a federal judgment. By the time a federal prisoner looks to file a second or successive motion, moreover, he will have had fewer bites at the apple and fewer courts reviewing his case than most state prisoners in the same position. Although the federal government has an interest in finality too, no legislation pursues its purposes at all costs. Allowing further review in this court is thus consistent with both AEDPA's purposes and practical considerations. At bottom, the government's arguments suggest that Section 2255H's cross-reference might include Section 2244B3E's certiorari bar. They do not, however, provide the necessary clear indication that Congress intended to close our doors to a class of habeas petitioners seeking review. Absent such clear indication, federal prisoners are not prohibited from seeking certiorari from a panel's denial of authorization to file a second or successive motion. Part 3. Turning now to the merits upon which the court granted certiorari, Bowe and the government agree that the 11th Circuit erred by applying Section 2244B1 to Bowe's request for authorization to file a second or successive motion to vacate under Section 2255H. The court appointed Kasdan M. Mitchell as amicus curiae to argue in support of the 11th Circuit's position. She has ably discharged her responsibilities. The court nevertheless agrees with the parties and holds that Section 2244B1 does not apply to motions filed by federal prisoners under Section 2255H. The contrary decision of the 11th Circuit is reversed. Section A. Begin with the text. Section 2244B1 states that a claim presented in a second or successive habeas corpus application under Section 2254 that was presented in a prior application shall be dismissed. State prisoners alone file habeas corpus applications under Section 2254. This specific reference to Section 2254 was deliberate. Elsewhere in this very section, Section 2244 acknowledges Section 2255. A cardinal rule of statutory interpretation teaches that when we're engaged in the business of interpreting statutes, we presume differences in language like this convey differences in meaning. Thus, by its plain terms, Section 2244B1's old claim bar applies only to state prisoners. Nor does Section 2255H's cross-reference to Section 2244 otherwise make Section 2244B1 applicable to second or successive motions filed by federal prisoners. Amicus, as well as the dissent, however, argues that it does. As they see it, Section 2255H incorporates Section 2244, including Section 2244B3C. Section 2244B3C, in turn, requires a panel to determine that the application makes a prima facie showing that it satisfies the requirements of this subsection. From here, one of the requirements of subsection B is Section 2244B1. Following this chain of cross-references where it leads, amicus and the dissent say Section 2244B1 must apply to federal prisoners. The reasoning why this court has jurisdiction also shows the error in this position. Section 2255H's cross-reference incorporates the procedures in Section 2244 only as they relate to how a panel certifies a second or successive filing. Then it tells the panel to use those procedures to evaluate whether the federal prisoner's second or successive motion contains either newly discovered evidence, Section 2255H1, or a new rule of constitutional law, Section 2255H2. Nothing in Section 2255H suggests that it incorporates Section 2244 for any other purposes. Thus, by its terms, Section 2255H's cross-reference does not incorporate the content requirements contained in Section 2244, like Section 2244B1's old claim bar. Amicus and the dissent's broad reading of Section 2244B3C would also put Section 2255 on a collision course with Section 2244. Section 2244B imposes two limitations on the content of a second or successive habeas application. Section 2244B1, which bars old claims, and Section 2244B2, which prescribes two grounds in which a claim not previously raised can proceed in a second or successive application. Section 2244b3c, on which amicus relies, requires individuals to satisfy all the requirements of this subsection, including both sections 2244b1 and b2. The upshot of amicus's argument would therefore be that section 2255H incorporates not only section 2244b1's old claim bar, but also section 2244b2's substantive gatekeeping requirements for new claims. Section 2255H, however, contains its own substantive requirements that are irreconcilable with those in section 2244b. In particular, section 2255H1 permits a second or successive 2255 motion if the petitioner identifies newly discovered evidence that, if proven and viewed in the light of the evidence as a whole, would be sufficient to establish by clear and convincing evidence that no reasonable fact finder would have found that movement guilty of the offense. Section 2244b2b also concerns claims based on new facts, but it is more limited than section 2255's in two ways. First, it confines the new facts exception to scenarios in which the new facts could not have been discovered previously through the exercise of due diligence. Second, it requires that the movement show by clear and convincing evidence that, but for constitutional error, no reasonable fact finder would have found the applicant guilty of the underlying offense. If Congress had incorporated section 2244b2b's more stringent exception into section 2255H, then section 2255H1's more lenient exception would become a dead letter. Because Congress presumably does not enact useless laws, it makes no sense to read section 2255H's cross-reference in this way. Recognizing the problem with this position, amicus and the dissent attempt to limit the scope of requirements of this subsection in section 2244b3c to capture only those content requirements in sections 2244b1 and b2 that do not conflict with section 2255H. In their view, Congress intended for the substantive gatekeeping requirements in section 2244b to apply to federal prisoners by default unless they deviated from those requirements in section 2255H. To amicus, the new facts exception illustrates this approach. This argument, however, is undercut by the fact that in section 2244b2a and section 2255H2, Congress repeated verbatim the standard for when a second or successive filing can proceed based on a new retroactive rule of constitutional law. If section 2244b2a already provided the default rule, there would have been no need for Congress to repeat it in section 2255H2, rendering its inclusion mere surplusage. At bottom, the best textual reading of both section 2255H and section 2244B is that when a federal prisoner moves for authorization, a panel can authorize the filing if it satisfies one of the two grounds in section 2255H, the two and only two conditions in which a second or successive 2255 motion may proceed. Section B. Amicus's remaining non-textual arguments do not change this conclusion. She contends that section 2244b1 is a necessary tool, indeed central, for panels to meet section 2244b3d's 30-day deadline, and that Congress therefore must have intended for it to apply in all cases in which authorization is needed. That logical leap lacks sufficient foundation. For one, it is not clear why searching through case files to see if the litigant has raised a claim before is any easier than determining whether the litigant has identified new evidence or a new rule of constitutional law that is retroactive. As the parties explain, it seems just as likely that the panel's obligation to assess only whether a filing has made a prima facie showing that it satisfies section 2255H's content requirements and not to undertake a more searching inquiry on the merits is what facilitates the 30-day deadline. Amicus certainly provides no evidence to suggest that her hypothesis is the more plausible one. Footnote 8. For support, amicus relies on the fact that the three circuits that do not apply Section 2244b1 to federal prisoners do not consider the 30-day deadline binding, suggesting that the failure to apply Section 2244b1's old claim bar is the reason for their failure to comply with the 30-day deadline in all cases. Amicus overlooks, however, that 3 out of the 6 circuits that apply Section 2244b1 to federal prisoners also do not treat that deadline as binding. Carrying on. Regardless, amicus's speculation as to Congress's intent in enacting the old claim bar and 30-day deadline cannot replace the actual text Congress enacted. Amicus further argues that Congress meant for AEDPA to treat second or successive filings by federal and state prisoners the same. As already explained, however, AEDPA is replete with examples of Congress treating state and federal prisoners differently, including in the context of limitations on second or successive filings. Footnote 9. This is not the only way in which Congress has treated old claims filed by federal and state prisoners differently. Section 2244C bars state prisoners from raising a claim or challenging facts in the federal post-conviction setting that were adjudicated by this court on direct review. This bar does not apply to federal prisoners, even though this court can also exercise jurisdiction over appeals on direct review of federal convictions. Carrying on. Some courts, including the 11th Circuit below, have relied on this policy justification and others like it in applying Section 2244b1 to bar second or successive motions filed by federal prisoners under Section 2255H. Those courts erred. Purposive argument simply cannot overcome the force of the plain text. Any concern associated with Congress allowing old claim repeat litigation for federal prisoners, moreover, is overstated. All claims, even the repeat ones, must meet the strictly limited threshold requirements of Section 2255H, and should they survive that review, they must still conform with the demanding statute of limitations contained in Section 2255F. Very few claims will satisfy either, let alone both. Ultimately, there is no reason to doubt that Congress said what it meant and meant what it said in Section 2244b1 and Section 2255H. Footnote 10. Although the common law did not apply traditional res judicata principles to habeas petitions, courts developed different equitable doctrines to address abuses of the writ. Congress can displace those doctrines, but in the absence of evidence of that intent, federal courts can continue to use those common law tools. Section 2244b codified a modified res judicata rule for second and successive petitions. As the government argues here, AEDPA may not have displaced other practices that courts can still use to address repetitive filings made by federal prisoners in the absence of Section 2244b1. Carrying on. For these reasons, Section 2244b1 does not apply to second or successive motions filed by federal prisoners challenging their convictions or sentences under Section 2255H. The court leaves it to the 11th Circuit to determine in the first instance whether Bowe should receive authorization to file a second or successive motion under the correct standard. The judgment below is vacated and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Jackson concurring. I agree with the court that under our precedents, Congress was required to say more if it wanted 28 U.S.C. Section 2244b3e to strip our jurisdiction over federal prisoners' requests for review of panel certification decisions. I likewise agree with the court's conclusion that Section 2244b1's bar on do-over claims in second or successive applications applies only to state prisoners. I write separately to offer my view of what Congress likely sought to accomplish with Section 2244b3e, insulating a three-judge panel's properly made, even if erroneous, gatekeeping determination from further review. The provisions language, our decision in Castro v. United States, and the broader statute's detailed gatekeeping scheme all support this interpretation. Because the three-judge panel here did not deny Bowe's petition pursuant to the statutorily prescribed procedures, I think it did not make the sort of determination Congress intended to insulate. Part 1. Section 2244b3e provides that the grant or denial of an authorization by a court of appeals to file a second or successive application shall not be appealable and shall not be the subject of a petition for rehearing or for a writ of certiorari. This provision thus prevents our court from reviewing a certiorari petition whose subject is the grant or denial of a request for authorization to file a second or successive application. That prescription does not cover Bowe's petition. In its decision below, the Court of Appeals did not grant or deny Bowe authorization to proceed on his successive claim. Rather, it dismissed the proposed claim for lack of jurisdiction. True, the label attached to an order does not erase its practical effect. But in this case, the distinction between a denial and a dismissal is practical, not semantic. As I read Section 2244b3e, a grant or denial occurs when a three-judge panel goes through the screening procedures Congress has prescribed and applies the appropriate criteria for second or successive claims. Footnote 1. Today's dispute encompasses a disagreement about which set of statutory criteria applies to federal prisoners, Section 2244b1 or Section 2255h. According to Justice Gorsuch, everyone agrees that Section 2244b3e precludes us from exercising certiorari jurisdiction to review an appellate panel's decision granting or denying certification to state prisoners. I agree with that assertion, but as I will explain, only insofar as it refers to appellate panel decisions that actually apply the statutory criteria and specified procedures for granting or denying state prisoners' authorization requests. Carrying on. Here, the three-judge panel never actually applied the relevant criteria to Bowe's motion, that is, the criteria for federal prisoners under Sections 2255H1 and H2. Instead, the panel reflexively dismissed Bowe's authorization request, holding that Section 2244b1's bar on do-over claims deprived it of jurisdiction, even though Section 2244b1 applies only to state prisoners for the reasons the court explains. As a result, a three-judge panel never undertook the required process for evaluating, i.e. for granting or denying, Bowe's authorization request. Put differently, because the panel dismissed Bowe's petition, there was no grant or denial of his authorization request that could be challenged in a petition for certiorari, as Section 2244b3e requires. This reading of Section 2244b3e finds support in Castro. That case, like this one, came to us in a distinct posture. Castro, a federal prisoner, filed a motion in the district court to vacate his sentence under Section 2255. Because Castro did not understand his motion to be second or successive, he did not first seek authorization from a three-judge panel in the Court of Appeals. Taking a different view than Castro, the district court dismissed the motion for failure to comply with the statutory restrictions on second or successive claims. On appeal, the 11th Circuit agreed with the district court's analysis and affirmed without evaluating Castro's motion on the merits. Castro subsequently filed a petition for a writ of certiorari, seeking to challenge the 11th Circuit's second or successive determination, but the government contended that we lacked jurisdiction under Section 2244b3e. We ultimately held that Section 2244b3e did not bar our review of Castro's petition. In so holding, we emphasized that Castro had not asked the Court of Appeals to grant and it nowhere denied any authorization to file a second or successive application. Instead, the case came to the 11th Circuit on appeal after the district court had already made its own determination about the viability of Castro's motion. In that posture, we explained the 11th Circuit had not made a statutorily relevant denial of a request for authorization, even though the court's conclusion had the effect of denying authorization to Castro. Against that procedural background, the subject of Castro's certiorari petition was not the Court of Appeals' denial of an authorization, so we retained our jurisdiction despite Section 2244b3e. So too here. To be sure, unlike Castro, Bowe's case has moved through the initial procedure for second or successive motions. That is, Bowe comes to us after first requesting authorization from a three-judge panel in the Court of Appeals. But just like Castro, the three-judge panel never made a statutorily relevant denial of Bowe's authorization request. To do so, the panel would have had to go through the applicable statutory criteria and determine whether Bowe's successive motion satisfied the conditions of sections 2255H1 and H2. Because the panel never made such a determination, it neither granted nor denied Bowe's authorization request as required to bar our review under section 2244B3E. Footnote 2. Because Castro's analysis calls for a statutorily relevant denial, it lays bare Justice Gorsuch's mistaken contention that a denial is a denial for section 2244B3E purposes. Reading the statute as I do also resolves the purported tension in the court's opinion that Justice Gorsuch elsewhere identifies. Why would the court take the trouble to show that Castro, a federal prisoner, wasn't pursuing a second or successive attack subject to subparagraph E if that provision had no bearing whatsoever on federal prisoners in the first place? The answer, of course, is that the court had no need to resolve subparagraph E's application to all federal prisoners when the provision so clearly did not apply to Castro. In other words, the court left open the question whether subparagraph E prevented our review in a certiorari petition whose subject actually is a statutorily relevant denial of a request for authorization to file a successive claim under 28 U.S.C. section 2255. I agree with today's conclusion that subparagraph E does not prevent our review under those circumstances. This separate writing observes only that Castro's logic likewise authorizes our review of Bowe's petition. Carrying on. Part 2. One might reasonably question why Congress would have crafted section 2244B3E to achieve such a technical distinction, barring further review of denials on the merits while permitting further review of the panel's use of the wrong criteria or procedures. As Justice Gorsuch points out, the effect is the same. Either way, the prisoner may not file his second or successive motion, but in my view, the distinction is not a technical or meaningless one. Instead, it fits neatly within and advances the gatekeeping scheme Congress established. For evidence, look no further than section 2244B3's other subparagraphs, which set forth a multi-part gatekeeping process for second or successive claims. First, a prisoner moves in the appropriate court of appeals for an order authorizing a second or successive claim. Second, a three-judge panel considers the request for authorization. Third, the panel determines whether the prisoner has made a prima facie showing of satisfying the relevant statutory requirements. Fourth, the panel issues its determination in no more than 30 days. With section 2244B3, Congress plainly erected a specific screening process for second or successive petitions, and with subparagraph E in particular, Congress afforded that process finality, but only if the prescribed procedures have been properly followed. By contrast, consider a panel that completely ignores the statute's specified gatekeeping requirements when making the authorization determination. Maybe the panel consists of 5 judges instead of 3, or maybe the panel automatically and arbitrarily denies all requests for authorization, refusing to evaluate whether the prisoner has satisfied the relevant statutory criteria. It would be exceedingly strange for us to conclude that Congress meant to insulate a rogue panel's actions from further review. Indeed, why would Congress devise such a detailed gatekeeping scheme while foreclosing review of its evasion? At bottom, then, section 2244B3E rationally operates as a finality provision designed to give a 3-judge panel the last say when the panel properly performs its gatekeeping function. But when the panel goes through the wrong procedures, as it did in Castro, or applies the wrong criteria, as it did here, it has not made the requisite grant or denial of an authorization that section 2244B3E insulates from further review. For that reason, in my view, even if Congress had spoken more clearly about section 2244B3E's application to federal prisoners, the panel's mistaken dismissal, instead of denial, of Bowe's petition makes section 2244B3E patently inapplicable. Justice Gorsuch, with whom Justice Thomas and Justice Alito join and with whom Justice Barrett joins as to Part 1, dissenting. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, courts of appeals serve an important gatekeeping function. When a state prisoner seeks to challenge his conviction or sentence in federal court for the first time, he normally proceeds directly to district court under 28 U.S.C. section 2254. But before a state prisoner may bring a second or successive attack in district court, AEDPA requires him to obtain a certificate from a panel of the relevant federal court of appeals. And under Section 2244, an appellate panel may certify a case to proceed only subject to certain demanding rules. Two are relevant here. First, an appellate panel may not authorize do-over claims the prisoner already presented in a prior federal challenge. Second, neither a state prisoner nor state authorities may file a petition for rehearing or seek a writ of certiorari to contest an appellate panel's decision granting or denying certification. AEDPA contains parallel directions for federal prisoners. When a federal prisoner seeks to challenge his conviction or sentence collaterally for the first time, he usually proceeds directly to district court under Section 2255. But before he can pursue a second or successive challenge, it must be certified as provided in Section 2244 by a panel of the appropriate court of appeals. Through that cross-reference, then, federal prisoners seeking to bring second or successive collateral attacks are generally subject to the same rules as their state counterparts. That brings us to Michael Bowe. After shooting 2 guards while trying to rob an armored vehicle in 2008, he pleaded guilty to 3 federal crimes. Since then, he has pursued 5 nearly identical post-conviction challenges. In each, Mr. Bowe has asserted that one of the statutes under which he was convicted, 18 U.S.C. Section 924C, is unconstitutional under our void for vagueness doctrine. And in all but the first of his challenges, Mr. Bowe has centered his argument around the same case, United States v. Davis. When Mr. Bowe sought permission to bring his latest collateral attack, the 11th Circuit demurred. Because he had pursued his Davis claim 3 times before, the court held that his latest filing represented an impermissible do-over claim barred by Section 2244b1. Now Mr. Bowe asks us to reverse the 11th Circuit's decision. Yes, he concedes AEDPA bars state prisoners from pursuing do-over claims, but he insists federal prisoners are different. They and they alone are free to bring the same claim in district court over and over again. Before we can take up that question, however, we must answer another. Under Section 2244b3e, Mr. Bowe acknowledges this court lacks certiorari jurisdiction to review an appellate panel's decision denying a state prisoner leave to file a second or successive collateral challenge. But here again, Mr. Bowe argues that federal prisoners are different. He submits that they, and once more they alone, are free to challenge adverse certification decisions on writ of certiorari. Because I do not believe that either of Mr. Bowe's pleas for federal prisoner exceptionalism can be squared with AEDPA's text, I respectfully dissent. Part 1. I understand my colleagues' eagerness to reach the merits of this case. As they observe, the courts of appeals are divided on the question whether federal prisoners like Mr. Bowe may pursue do-over claims. Doubtless, too, it is often this court's job to resolve circuit splits and bring nationwide uniformity to the application of federal law. But it is also one of our paramount responsibilities to respect the limits of our jurisdiction, and, to my eyes, AEDPA precludes us from exercising certiorari jurisdiction here. Section 2244 instructs that the grant or denial of authorization by a court of appeals to file a second or successive collateral attack shall not be the subject of a petition for a writ of certiorari. Everyone agrees this provision precludes us from exercising certiorari jurisdiction to review an appellate panel's decision granting or denying certification to state prisoners, and because Section 2255H tells us that the same rules apply to federal prisoners, exactly the same outcome follows for federal prisoners like Mr. Bowe. Importantly, though, that does not mean we lack for ways to resolve the circuit split my colleagues worry over. AEDPA may prevent us from exercising certiorari jurisdiction under Section 1254(1), but AEDPA not only leaves untouched our power to entertain original habeas petitions filed directly to this court, AEDPA also leaves untouched our power to accept certified questions of law from the federal courts of appeals and provide them with binding instructions on how to answer those questions under Section 1254(2), a provision found right next door to the one governing our certiorari jurisdiction. Accustomed as we are to proceeding by way of certiorari under Section 1254(1), it's true that we have rarely accepted certified questions under Section 1254(2), but a rare procedure befits rare circumstances. and this case involves a rare circumstance indeed, a circuit split that would otherwise stagger on forever. Rather than ignore Section 2244's express constraint on our certiorari jurisdiction, then, we might have simply signaled to the courts of appeals our willingness to accept certification in this or a similar case. Section A. To appreciate why we lack certiorari jurisdiction, it helps to start with a bird's-eye view of how AEDPA addresses second or successive collateral attacks. AEDPA seeks to advance the finality of criminal convictions. It does so in part by imposing strict limits on the ability of federal and state prisoners to bring multiple post-conviction attacks in federal court. So, for example, a federal prisoner's second or successive collateral attack must be certified to contain a showing of either new facts or new law. The new facts route requires the prisoner to show that he possesses newly discovered evidence that, if proved, would establish his innocence clearly and convincingly. The new law route requires him to argue that his conviction or sentence is unlawful in light of a new rule of constitutional law that this court has made retroactively applicable to cases on collateral review. Similar rules apply to state prisoners under Section 2244b2. Footnote 1. Put aside for the moment AEDPA's additional instructions about do-over claims. They become relevant only when we come to the merits. Carrying on. Even beyond those constraints, AEDPA imposes others. A federal prisoner's second or successive Section 2255 attack not only must contain either new facts or new law, it must also be certified as provided in Section 2244. Everyone agrees this cross-reference directs us to Section 2244b3. That paragraph provides these instructions. Quote, before a second or successive application permitted by this section is filed in the district court, the applicant shall move in the appropriate court of appeals for an order authorizing the district court to consider the application. A motion in the Court of Appeals shall be determined by a 3-judge panel of the Court of Appeals. The Court of Appeals may authorize the filing of a second or successive application only if it determines that the application makes a prima facie showing that the application satisfies the requirements of this subsection. The Court of Appeals shall grant or deny the authorization not later than 30 days after the filing of the motion. The grant or denial of an authorization shall not be appealable and shall not be the subject of a petition for rehearing or for a writ of certiorari. End quote. With this overview in hand, our lack of certiorari jurisdiction quickly becomes clear. Section 2244b3e prohibits a state prisoner from invoking our certiorari jurisdiction to challenge an order denying him leave to file a second or successive collateral attack. Indeed, this court has already held as much. And Section 2255h tells us that a federal prisoner seeking to pursue a second or successive collateral attack must obtain certification as provided in Section 2244 for state prisoners. Accordingly, the same bar on certiorari applies. That common sense conclusion finds unanimous support in the Court of Appeals. Just as Section 2244b3e bars certiorari petitions, it also bars petitions for panel en banc rehearing. Since AEDPA's adoption in 1996, a great many federal prisoners have sought rehearing on the theory that this rule applies only to state prisoners, not them. Yet every circuit to consider that approach has rejected it, recognizing instead that subparagraph E applies to federal prisoners no less than their state counterparts, and thus prohibits them from petitioning for panel or en banc rehearing. Our own precedent carries the same message. In Castro v. United States, the government argued that subparagraph E precluded this court from considering a federal prisoner's challenge to an appellate panel decision denying him leave to file a second or successive attack. At the same time, the government contended the terms of subparagraph E leave it free to challenge many appellate panel decisions granting a federal prisoner permission to proceed. The court rejected both submissions. First, after conducting a painstakingly detailed analysis of the filing history of the particular prisoner before it, the court concluded that his challenge was not, in fact, second or successive, so subparagraph E, which applies only to second or successive challenges, simply was not implicated in the case at hand. Second, the court rejected the government's anomalous suggestion that subparagraph E might allow it, but not a prisoner, to challenge an adverse appellate panel decision regarding a second or successive filing. Neither holding makes sense unless subparagraph E applies to federal prisoners pursuing second or successive collateral attacks. Why take the trouble to show this federal prisoner wasn't pursuing a second or successive attack subject to subparagraph E, and why bother rejecting the government's lopsided argument about how subparagraph E works if subparagraph E has no bearing whatsoever on federal prisoners in the first place? While Castro may not have announced a holding that subparagraph E applies to federal prisoners pursuing second or successive collateral attacks, all of its work was surely grounded on that premise. Our decision in Hone v. United States is equally telling. That case concerned 28 U.S.C. Section 2253C, which requires a federal prisoner to obtain a certificate of appealability before he may appeal a district court's adverse decision in a Section 2255 proceeding. The jurisdictional question before the court was whether a court of appeals denial of a COA is a case within the meaning of Section 1254(1) and thus reviewable on certiori. Concluding that it is, the court leaned heavily on a comparison between Section 2253C and Section 2244B3E. The latter provision, the court said, imposes a clear limit on our jurisdiction, and the court reasoned the existence of that clear limit coupled with the absence of comparable language in Section 2253C suggested that federal prisoners may seek certiorari to challenge an adverse COA decision. Much as in Castro, the court in Hone may not have expressly reached a holding about Section 2244B3E's meaning, but its work only makes sense if that provision clearly precludes certiorari jurisdiction for federal prisoners. Really, the idea that Section 2244B3E applies to federal prisoners and bars them from seeking certiorari has been uncontroversial since AEDPA's adoption 3 decades ago. So much so that until recently, even the author of today's majority opinion accepted it. In another case involving Mr. Bowe, yes, the same Mr. Bowe, our colleague urged the court to consider accepting an original habeas petition to resolve the very same do-over circuit split now before us. Invoking that unusual procedure, our colleague insisted it was necessary precisely because Section 2244B3E's bar on petitioning for review would preclude Mr. Bowe from invoking our certiorari jurisdiction. That was right then, and it is right still. Section B. How does Mr. Bowe respond? He does not dispute that all the rules laid out in Section 2244B3A through E apply to state prisoners. As a result, he acknowledges neither state prisoners nor state officials may challenge an appellate panel's certification decision on certiorari. Accordingly, there are only 2 ways to resolve circuit splits about Section 2244 in the state prisoner context: original habeas writs and certification under Section 1254(2). Even when it comes to federal prisoners, Mr. Bowe cedes much ground. He admits that Section 2255H subjects federal prisoners to the same rules that apply to state prisoners in Sections 2244B3A, B, C, and D. He concedes, too, that every court of appeals to consider the issue has held that subparagraph E also applies to federal prisoners. Still, Mr. Bowe insists he's discovered something all those courts and this one have missed for the last 30 years. Subparagraph E, and it alone, doesn't apply to federal prisoners. His theory runs this way. Section 2255H instructs that a federal prisoner's second or successive attack must be certified as provided in Section 2244. That language Mr. Bowe submits sweeps in only those parts of Section 2244 that address how an appellate panel goes about certifying a second or successive filing, and it does not sweep in subparagraph E because, unlike all of Section 2244B3's other subparagraphs, it does not provide for certification. It may be a wonderfully convenient theory for Mr. Bowe, but no court has adopted it for good reason. Just look again at the block quotation of statutory text above. Each and every one of Section 2244B3's subparagraph provides for how a second or successive collateral attack must be certified by a panel of the appropriate court of appeals. Subparagraph A routes the certification decision to a court of appeals. Subparagraph B directs that the decision must be made by a 3-judge panel. Subparagraph C sets forth the standard the panel must use when deciding whether to certify. Subparagraph D specifies the timing for a decision, and subparagraph E provides that the panel certification is the exclusive avenue for certification decisions without foreclosing the panel from asking this court via Section 1254(2) for instructions on questions of law along the way. What begins with an application to a three-judge panel under subparagraph A ends with its disposition by the same panel under subparagraph E. Notice too the hash Mr. Bowe's interpretation makes of the rest of the statute. Subparagraph B mandates that a certification motion shall be determined by a three-judge panel of the Court of Appeals. What would be the point of that direction if, as Mr. Bowe suggests, a prisoner could petition a court of appeals en banc or this court on certiorari to certify a second or successive collateral attack instead? Plainly, subparagraph E works in tandem with subparagraph B to ensure that the certification decision comes from and only from a three-judge panel. Ignoring E undermines B. Ignoring E also makes a nonsense paragraph of D's instruction requiring a panel to grant or deny certification within 30 days. That mandate is perfectly sensible if, as subparagraph E provides, the decision of a three-judge panel is final. But it is wholly insensible if, as Mr. Bowe supposes, any prisoner can seek panel rehearing, then en banc rehearing, and certiorari too. The entire point of AEDPA and its certification process was to reduce delays and advance the finality of criminal convictions. Yet, on Mr. Bowe's reading, the certification process alone would typically take not 30 days, but many multiples of that. Footnote 2. Mr. Bowe suggests this is no problem because subparagraph E allows courts of appeals to order rehearing sua sponte. And having discovered porosity in this otherwise solid subparagraph, Mr. Bowe wonders why we need to worry about finality at all. But even if AEDPA tolerates sua sponte rehearing, that is no threat to finality because sua sponte rehearing is rare and judges do not call for it needlessly. The same is true of certification under Section 1254(2) for that matter. These modest, rarely employed, and judicially initiated procedures are hardly camel's noses poking under AEDPA's tent. Carrying on. Section C. Mr. Bowe's line of argument understandably causes my colleagues some discomfort. Thankfully, they are unwilling to say, as Mr. Bowe does, that every court of appeals to have reached the issue has erred in holding that subparagraph E bars federal prisoners from seeking panel or en banc rehearing. To avoid calling those sound decisions into question, the majority pivots in a different direction. On its theory, even if subparagraph E bars federal prisoners from pursuing petitions for panel and en banc rehearing, the statute does not bar them from seeking certiorari. There's an obvious reason Mr. Bowe did not press that eccentric theory before us. It cannot be squared with the statutory text. Section 2255 instructs that a federal prisoner's second or successive attack must be certified as provided in Section 2244, and what subparagraph E provides is a package deal. The statute bars rehearing petitions and certiorari petitions in a single breath. It provides that a panel certification decision shall not be the subject of a petition for rehearing or for a writ of certiorari. The notion that all of subparagraph E might apply to federal prisoners minus the 6 words "or for a writ of certiorari" is utterly implausible as a textual matter. One might think this problem would cause the majority to hesitate. Instead, my colleagues plow on, conjuring up a clear statement rule to support their course. Yes, the majority admits a fair reading of Section 2255H's cross-reference to Section 2244 might include Section 2244B3E's certiorari bar. But, my colleagues insist, Congress must speak clearly when it wishes to withdraw our certiorari jurisdiction, and the language Congress employed here is not clear enough to be worth following. There is no avoiding the odd contours of the majority's clear statement rule. Apparently, Congress may restrict and channel collateral review in lower courts as it has done in subparagraphs A through D. Congress may also bar petitions for panel or en banc rehearing as it has done in subparagraph E, cutting off the usual method by which a court of appeals reconciles its internal difficulties. Seemingly, Congress can do all that without having to satisfy any clear statement rule. The only work the majority's rule performs concerns certiorari petitions, and the only effect that rule has is to pencil out subparagraph E's 6 words "or for a writ of certiorari" in cases involving federal prisoners, and while leaving those same 6 words in force when it comes to state prisoners. That gerrymandered rule may suit Mr. Bowe's present needs and appeal to our vanity, but it is pointless. Even if a clear statement rule were required here, Congress gave us one. For all the reasons explored above, AEDPA's certiorari bar imposes, in Hohn's words, a clear limit on our jurisdiction. Nor, again, is there any need to pretend otherwise just to address the circuit split Mr. Bowe identifies, for we can just as easily reach it through certification under Section 1254.2 as we can through certiorari under Section 1254.1. Indeed, the 11th Circuit refused to invoke Section 1254.2 only because it believed we would deny certification, a belief we could easily dispel in this case simply by saying it isn't so. Worse still, the majority's bespoke certiorari for federal prisoners clear statement rule lacks any grounding in law. Just ask yourself, if not from thin air, where could such a rule possibly come from? Perhaps the most obvious candidate would be the Constitution. Sometimes, after all, when faced with two competing statutory interpretations, this court invokes the canon of constitutional avoidance to choose the one that avoids rather than implicates a constitutional problem. But the majority does not rest its clear statement rule on that doctrine, nor could it. This court has already expressly rejected the notion that Section 2244b3's limitation violate the suspension clause or the exceptions clause, the two constitutional provisions most obviously relevant to cases like this one. That should come as no surprise either. The writ of habeas corpus traditionally addresses cases of executive detention without trial. Accordingly, a federal prisoner was ineligible for habeas corpus if he had been convicted by a court of competent jurisdiction. It was not until the 20th century that this court began allowing federal prisoners to mount collateral attacks on jurisdictionally sound convictions. Put simply, for much of our nation's history, there was no collateral review of the vast majority of convictions, much less a right to certiorari in such cases. With constitutional avoidance off the table, the majority advances an unbriefed theory to prop up its novel clear statement rule. Citing Bockler v. Commissioner, the majority observes that this court generally reads statutorily prescribed procedural requirements as forfeitable claim processing rules rather than unwavering jurisdictional mandates unless Congress clearly indicates otherwise. And the majority insists it is doing something similar here. No one disputes that AEDPA's certiorari bar at issue here is jurisdictional, so Bockler not only does not control this case, it has nothing to say about this case at all. The majority's invocation of Bockler is not just inapt, it is unfortunate. 2 years ago, in an obscure administrative law case, this court expressly refused to treat Bockler as a permission slip for creating any manner of new interpretive presumptions that may happen to suit our tastes, but that do not approximate real statutory meaning. Yet that is exactly how the majority treats Bockler today. The picture does not improve from there. The Bockler clear statement rule operates only in a particular context and exists only for particular reasons. Treating too many rules as jurisdictional rather than as claim processing rules, this court has said, would result in the waste of judicial resources and may unfairly prejudice litigants. Yet neither of those rationales applies here. If anything, it is the majority's new rule that promises to waste judicial resources by undermining finality, and there is no colorable argument that Congress acts unfairly by preventing both prisoners and governments from appealing adverse certification decisions. Far from respecting Bockler, then, the majority more nearly defies it. With Bockler a dry hole, the majority finds itself forced to prospect elsewhere for legal authority. Its next stop is Castro, but the majority's quote mining of that decision only winds up highlighting just how unprecedented its course today really is. In Castro, remember, the government advocated for a lopsided construction of Section 2244b3e. On the government's view, the statute permitted it to seek certiorari to challenge a circuit decision granting certification, but precluded a federal prisoner from seeking certiorari to challenge a circuit decision denying certification. As we have seen, the court rejected that submission for two reasons. First, the prisoner there did not seek to pursue a second or successive attack subject to subparagraph E. Second, the government's reading would have closed our doors to a class of habeas petitioners seeking review while leaving those same doors open to the government. Expanding on the second rationale, the court said it would not endorse such an anomalous reading of subparagraph E without any clear indication that such was Congress's intent. Doubtless, this commentary reflected an intuition that Congress would not lightly treat similarly situated litigants differently, but none of that speaks to the situation before us, where the construction of subparagraph E at issue is fair and square, no certiorari review of certification decisions, no matter who won below. If anything, as we have seen, Castro does more to hurt than help the majority's cause. Throughout the decision, the court took as given that subparagraph E does bar federal prisoners from seeking certiorari to challenge adverse certification decisions regarding their second or successive filings. Why, again, would Castro take the trouble to explain that the challenge there wasn't a second or successive one if subparagraph E doesn't apply to federal prisoners anyway? And why would Castro worry about the anomalous possibility that only the government may seek certiorari when, in fact, federal prisoners can too? The majority offers no colorable answers to these questions because none can be had. Just like Hone and our colleague's opinion 2 years ago in re Bowe, Castro fully appreciated that subparagraph E imposes a clear limit on our certiorari jurisdiction, one applicable to federal and state prisoners alike. Footnote 3. Attempting to wring more yet from Castro, the majority points to its citation of Utah v. Evans for the principle that we read limitations on our jurisdiction to review narrowly. But Evans simply applied the adenine presumption that federal agency action is amenable to some form of judicial review. That presumption speaks not at all to the post-conviction setting, let alone second or successive collateral attacks like this one. In this context, a litigant has already enjoyed extensive judicial review, including at least 2 opportunities to seek certiorari from us, first on direct review and again in a first post-conviction challenge. Carrying on. Unable to identify any plausible authority in existing law for its clear statement rule, the majority is ultimately left to summon it from the ether. To be sure, my colleagues begin by pointing to the unremarkable principle that this court does not read statutory silence as implicitly modifying or limiting jurisdiction that another statute specifically grants. But from there, the majority engages in pure invention, devising a broad new legal rule that even express limitations on our certiorari jurisdiction are unenforceable absent a clear statement. What a leap that is! This case is nothing like those in which we have historically declined to infer limitations on our certiorari jurisdiction based on statutory silence. All agree that Section 2255H expressly incorporates portions of Section 2244B3. All agree that Section 2244B3E expressly bars petitions for writs of certiorari. The only point of disagreement concerns how those explicit provisions fit together. I believe they fit together in a way that deprives us of jurisdiction, but even if I'm wrong about that, this is hardly a case of silent or ambiguous text, nor one involving provisions that make no mention of our authority. Truly, the majority's clear statement rule comes from nowhere at all. In the end, neither Mr. Bowe's textual arguments nor the majority's atextual theory can obscure AEDPA's message, one every court of appeals and this court has understood since 1996. A litigant like Mr. Bowe may seek to pursue an original habeas petition in this court. A court of appeals may certify questions to us, but Section 2244 bars state prisoners and governments from invoking our certiorari jurisdiction to challenge adverse certification decisions. Section 2255 extends that bar to federal prisoners, and because that bar applies here, we lack jurisdiction to decide this case. The majority's conclusion otherwise is as improbable as it is novel. Footnote 4. In a final foray, Mr. Bowe and Justice Jackson contend that even if subparagraph E's certiorari bar generally applies to federal prisoners, it still does not apply in this particular case. Mr. Bowe's version of the argument goes like this. Subparagraph E bars certiorari petitions from appellate orders that grant or deny certification to pursue a second or successive attack, and Mr. Bowe submits that language doesn't apply to him because the 11th Circuit dismissed rather than denied his certification request. This argument fails, though, because the label attached to an order is not dispositive. Its practical effect is. And here, the practical effect of the 11th Circuit's dismissal order was to deny Mr. Bowe permission to pursue his second or successive attack. Justice Jackson's version of the argument proceeds differently. She admits that a dismissal may have the practical effect of a denial, But she insists that doesn't hold true here because by applying Section 2244b1's do-over bar, the 11th Circuit applied the wrong statutory criteria to Mr. Bowe. There's just one problem. The statute bars review for any grant or denial, not any grant or denial made after applying the correct statutory criteria. Justice Jackson identifies nothing in the statute's terms that might allow us to turn the 11th Circuit's supposed merits error into a jurisdictionally decisive event. A denial is a denial. Recognizing the flaws of both versions of the argument, the majority rightly adopts neither. Carrying on. Part 2. Because the majority concludes that we have jurisdiction to reach the merits, I offer my views too. The question here, recall, concerns the 11th Circuit's refusal to certify Mr. Bowe's latest collateral attack. Like most other circuits, the 11th Circuit has held that Section 2244b1 bars do-over claims by both state and federal prisoners. And that provision, the court reasoned, barred Mr. Bowe's present challenge because he has already pursued the same challenge many times before. In reversing the 11th Circuit, my colleagues do not question that Section 2244b1 prohibits state prisoners' do-over claims, nor do my colleagues question that Mr. Bowe seeks to pursue a do-over claim in this case. Instead, they hold that federal prisoners like him are free to file in district court as many do-over claims as they please. Once more, I disagree because I see nothing in AEDPA's text that supports that kind of special treatment for federal prisoners. Section A. Begin by walking through the relevant statutory provisions. Section 2255 requires a federal prisoner to satisfy two essential requirements before he can pursue a second or successive challenge. First, his filing must contain either new facts or new law sufficient to satisfy Section 2255H1 or H2. Second, his filing must be certified by a court of appeals under the rules outlined in Section 2244. And to win certification under Section 2244, everyone except a federal prisoner must satisfy at least Sections 2244b3, A, B, C, and D. With jurisdiction now out of the picture, we can set aside the dispute over E. From there, the right answer lies only a few steps away. Section 2244b3c states that the Court of Appeals may authorize the filing of a second or successive application only if it determines that the application makes a prima facie showing that the application satisfies the requirements of this subsection. No one questions that this provision applies to state and federal prisoners equally. So, by its terms, this provision means a federal prisoner must make a prima facie showing in a court of appeals that his second or successive filing satisfies the requirements of this subsection, namely subsection B of Section 2244. That tells us all we need to know. The very first provision of subsection B prohibits do-over claims. In the words of Section 2244b1, any claim presented in a prior application shall be dismissed. As a result, AEDPA no more tolerates repetitive litigation by federal prisoners than it does by state prisoners, and the 11th Circuit was right to deny Mr. Bowe leave to file again the same claim he had already pursued many times before. What the statutory language teaches on this point, context confirms. Next to subsection B1 sits subsection B2. There, Congress addressed second or successive filings presenting new, as opposed to do-over, claims. As laid out in the margin, subsection B2's rules for state prisoners' new claims are similar to, but different from, Section 2255H's rules for federal prisoners' new claims. Footnote 5. Section 2244B2B's new facts provision requires that, quote, 1. The factual predicate for the claim could not have been discovered previously through the exercise of due diligence, and 2. The facts underlying the claim, if proven and viewed in the light of the evidence as a whole, would be sufficient to establish by clear and convincing evidence that, but for constitutional error, no reasonable fact finder would have found the applicant guilty of the underlying offense. End quote. In contrast, Section 2255H1's new facts provision requires, quote, newly discovered evidence that, if proven and viewed in the light of the evidence as a whole, would be sufficient to establish by clear and convincing evidence that no reasonable fact finder would have found the movement guilty of the offense. End quote. Carrying on. And because Section 2255H applies particularly to federal prisoners, its specific requirements displace Section 2244B2's more generally applicable ones. So when a court of appeals asks whether a federal prisoner has made a prima facie showing that his proposed filing satisfies the requirements of this subsection under Section 2244b3c, the requirements of Sections 2255h1 through 2 step into the shoes that Section 2244b2 would otherwise fill. Tellingly, however, Section 2255H contains no such federal prisoner-specific language when it comes to do-over claims. Instead, it leaves Section 2244b1's generally applicable language in place, all of which suggests that Section 2244b1 applies no less to federal prisoners than to state prisoners, just as the text says. Footnote 6. The majority claims my understanding of how Section 2244b2 and Section 2255h interact renders Section 2255h2 mere surplusage, but that claim is easily falsified. If Section 2255h2 really were mere surplusage, then it would be struck out of the statute with no change. So then, imagine a version of Section 2255h without subsection h2. That imaginary provision would require every second or successive motion to contain newly discovered evidence capable of satisfying subsection h1's new facts requirement. That is very different from the real Section 2255h, which allows a prisoner to show either new facts or new law. Carrying on. Another contextual clue comes from the 30-day clock. Just as with Section 2244b3c, no one questions that Section 2244b3d applies to both federal and state prisoners. Under that provision, a federal court of appeals has just 30 days to issue a certification decision. Complying with that tight deadline is possible if courts of appeals can dispose of do-over claims without further inquiry. But complying is a good deal harder if panels must ask whether each and every proposed collateral attack involves new evidence of innocence or a retroactively applicable rule of constitutional law. In this case, for example, it took me 5 minutes to appreciate that Mr. Bowe has already advanced many times before the same claim he proposes to pursue here. I do not know, nor would it be so easy to determine, whether Mr. Bowe's latest filing makes a compelling showing of new facts or new law. Statutory structure and history, too, have something to say. Before AEDPA, separate provisions addressed do-over claims by state prisoners and federal prisoners. Back then, Section 2244 permitted but did not require a court to deny relief to a state prisoner who presented no new ground not heretofore presented and determined in a prior application. Similarly, Section 2255 said that a court shall not be required to entertain a second or successive motion for similar relief by a federal prisoner. In AEDPA, Congress amended both provisions. Now, Section 2255H channels second or successive Section 2255 motions through the Section 2244 rules applicable to state prisoners, and AEDPA added to Section 2244 a new mandatory, no longer permissive, bar against do-over claims, flatly directing that they shall be dismissed. Exactly nothing in this history or AEDPA's structure suggests Congress sought to loosen do-over restrictions for anyone, let alone completely do away with those restrictions for federal prisoners. To the contrary, the statute's history and structure suggest, as we have long observed, that AEDPA imposes new and stricter limits on post-conviction relief. All of which indicates, once again, that Congress meant what it said in Section 2244b3c. The requirements of this subsection apply to federal and state prisoners alike, and those requirements include subsection B1's bar on do-over claims. Section B. Seeking some way to justify a rule prohibiting state prisoners from pursuing do-over claims, but also allowing federal prisoners to do just that, Mr. Bowe and the majority offer a grab bag of unpersuasive theories. First, the majority observes that Section 2244A specifically references Section 2255, the provision governing federal prisoners' collateral attacks, while Section 2244B1 contains no such reference. Because we presume differences in language convey differences in meaning, the majority submits, it must follow that Section 2244B1's bar on do-over claims applies only to state prisoners. But that cannot be right. Section 2244 mentions Section 2255 only one time in Section 2244A. If its absence elsewhere mattered, then none of the rules in Sections 2244b3a through d would apply to federal prisoners, yet not even the majority or Mr. Bowe thinks that. To the contrary, both concede that the whole point of Section 2255H's cross-reference to Section 2244 is to ensure federal prisoners, just like their state counterparts, must follow each of those provisions. Second, and in a similar vein, Mr. Bowe stresses that subsection B1 prohibits do-over claims in a second or successive habeas corpus application under Section 2254. Seeking to capitalize on the italicized language, Mr. Bowe notes that Section 2254 governs post-conviction applications by state prisoners while federal prisoners proceed by way of Section 2255 motions. Given that difference in nomenclature, Mr. Bowe contends subsection B1 must apply only to state prisoners because that provision addresses applications and not motions. The majority briefly nods in the same direction. This argument fails for much the same reason as its predecessor. If the absence of the word motion in Section 2244 made all the difference, then none of Sections 2244b3a through d's rules would apply to federal prisoners because each of those provisions speaks only of applications. Yet no one believes that. Instead, everyone appreciates Section 2255 routes federal prisoners' motions through all those provisions. In each, then, the word applications is best read as interchangeable with motions, just as most circuits have understood. Third, Mr. Bowe replies that there's something else special about subsection B1. Unlike sections 2244b3a through d, he says subsection B1 doesn't just speak of applications, but applications under section 2254. And that more specific reference, Mr. Bowe insists, means subsection B1 cannot apply to federal prisoners proceeding under section 2255. But this argument doesn't move the needle either. If, as it must be and as no one seriously disputes, the term application in section 2244 is best read as embracing the federal section 2255 motion, then the phrase application under section 2254 in section 2244 should likewise be understood to embrace a motion under section 2255. Footnote 7. That is not to say that subsection B1's specific reference to section 2254 applications rather than to applications simpliciter is superfluous. It has considerable work to do, just not the work Mr. Bowe supposes. By referencing section 2254, the statute makes plain that the do-over bar applies only to applications, or motions as the case may be, by prisoners seeking post-conviction relief. That renders it inapplicable to habeas applications from state prisoners in pre-conviction executive detention because those applications are filed under section 2241 rather than section 2254. And that distinction, unlike the one Mr. Bowe proposes between state and federal prisoners, makes sense. Convicted prisoners, by definition, have already received a great deal of judicial process, so a do-over bar makes sense as to them. Prisoners who haven't been convicted, meanwhile, stand in very different shoes, so Congress decided to exempt them. Carrying on. Fourth, the majority suggests that Section 2255H's cross-reference to Section 2244 captures only the latter's procedures governing how a panel certifies a second or successive filing. And the argument goes, Section 2244b1's bar on do-over claims is no mere procedure, but instead a substantive rule about what a filing may contain. This theory fails too. Section 2255's cross-reference does not speak of a procedure-substance distinction. Instead, Section 2255H directs courts to certify motions as provided in Section 2244. Even the majority acknowledges that this language makes Section 2244b3c applicable to federal prisoners, and subparagraph C explicitly says the requirements of this subsection, which include Section 2244b1, must be satisfied before certification. It's more than a little telling that the majority finds itself forced to both rewrite Section 2255H's terms and to ignore Section 2244b3c's directions. Finally, Mr. Bowe retreats to the position that federal prisoners must be exempt from subsection B1 because AEDPA was designed to treat state prisoners more harshly than federal prisoners. But in fact, AEDPA often treats the two groups the same, and not just when it comes to second or successive filings. To take just one example, Section 2253C requires a prisoner to secure a certificate of appealability before appealing from a habeas or Section 2255 loss in federal district court. State and federal prisoners alike thus must satisfy that provision's demands. And it should shock no one that Congress might proceed similarly here and exhibit an intolerance for do-over claims no matter who seeks to pursue them. Footnote 8. The government offers two additional theories for Mr. Bowe on the merits, but the majority pursues neither theory, and rightly so. For one, the government appears to suggest that subsection B1 never applies during Court of Appeals certification proceeding for any prisoner, state or federal. Only after certification on this view may a district court weed out do-over claims under subsection B1. But among other defects, the government's view would imply that not only B1 but also B2 is inapplicable during certification, and of course that would render the whole certification process pointless. For another, the government suggests that even if Section 2244B1's do-over bar applies to federal prisoners, that rule does not apply in this particular case because Mr. Bowe never actually filed a previous collateral attack containing a Davis claim. He only sought leave to do so. But we did not take this case to address that case-specific argument, nor did Mr. Bowe himself clearly advance it before us. Carrying on. The majority today commits two serious mistakes. First, in its zeal to resolve a circuit split, the majority asserts jurisdiction where we have none. With statutory text and 30 years of case law in this court and lower courts align against it, the majority bases its claim of jurisdiction on a new and curiously contoured clear statement rule that is as needless as it is unprecedented. Second, and compounding its jurisdictional overreach, the majority adopts an implausible view on the merits. AEDPA didn't suddenly free federal prisoners from pre-existing restrictions on do-over claims. Just the opposite, it imposed additional carefully crafted limits on collateral attacks by federal and state prisoners alike, and, quite unsurprisingly, one of those limits includes an unmistakable and absolute bar on do-over claims. Because neither of the majority's innovations are compatible with Congress's directions in AEDPA, I respectfully dissent. And that does it for the opinions in this case. As for my thoughts, I had to very carefully write my thoughts down as I was reading this and recording, because these opinions were just really confusing to read. Because first of all, it's a really weird specific area of the law that obviously I don't have a whole lot of knowledge on. I don't go out of my way to read case law on habeas petitions and related petitions by federal prisoners, and the process for making second or successive petitions, and and then there's the fact that you've got different provisions of related laws that are applying to state and federal prisoners that are cross-referencing each other. And I went and looked at the statutory text, and they actually cross-reference each other multiple times. They also cross-reference other statutes. So not the easiest thing in the world to keep track of in my mind. It also doesn't help that obviously you've got a whole bunch of references to Section 2255 and Section 2254. They're, the numbers are very similar, so keeping those straight in my head was difficult. Brief interjection: while I'm editing this episode, I noticed that I said Section 2255 and Section 2254, when what I meant was Section 2255 and Section 2244, which is kind of ironic given that I was talking about how difficult it was to keep the different statutes straight in my head given how similar the numbers are. It also doesn't help that there is the occasional reference to Section 2254, which is also cross-referenced by the relevant statutes. So, anyway, interjection over, carrying on. And they're referencing very specific subsections like 2255H and 2244 B3 A through D and B3E, and and then on the merits 2244 B1, and it's a lot. So I don't know if you found it similarly confusing, but I certainly did. One of the first thoughts that I had, though, was actually not particularly related. Not related to the question presented in this case, but um, was on the residual clause of, I think it was section 924, and its definition of a crime of violence. That residual clause being found unconstitutionally vague in Davis was pretty interesting to me, because like unconstitutional vagueness is not an easy thing, as I understand it, to show. And the void for vagueness doctrine is, in my opinion, really important, because regular people need to be able to understand the laws that are being applied to them. And especially in this day and age, that's really hard, because regular people are subject to a whole hell of a lot of criminal laws at the federal level, the state level, and more locally than that, municipalities and cities and counties and whatever. And so finding a law to be unconstitutionally vague just in and of itself kind of interested me. And it makes sense that happened with this law in particular, because like I found myself while reading the cited language before the court pointed out that it was found unconstitutional or unconstitutionally vague. While reading the cited language, I found myself thinking, what in the hell does that mean? I mean, defining a crime of violence as a felony, quote, that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense, end quote. Like, what? So a court has to imagine the sort of like archetypical version of this crime to figure out what the crime's nature is. And then does that nature involve a substantial risk that physical force against the person or property of another may be used? And how much risk is a substantial risk? And it's just, how on earth are you supposed to be able to tell if this law applies to you? I mean, obviously, like, it's going to apply to people committing felonies, but that doesn't change the fact that even people committing felonies, committing acts that are otherwise crimes already, like, they still have a constitutional right to know what laws are actually applying to their conduct, or like to be able to comprehend what laws are applying to their conduct. And this law, you really just can't. Even if you sit there and read it, you're like, okay, well, was this offense one that by its nature involves a blah, blah, blah? Like, I don't know. So that interested me. And by the way, Gorsuch opinion. So, kind of cool there. And I like, when I read that this was an unconstitutional vagueness decision, I was like, that feels like a Gorsuch thing. And it was from 2019, so Gorsuch would have been on the court at the time. And so I was like, I want to look this up and see who wrote this, and like just skim it real quick. And yeah, sure enough, Gorsuch opinion. So that's cool. Anyway, on to the actual the actual question, or at least my thoughts on it. Even while reading the majority's opinion and having not read anything else, so this is the best that the majority's opinion is going to look in my mind, because I'm not reading the dissent, I'm not reading any of the pushback. I'm just reading the majority making its case as best as it can. Even there, it's even in that context, it felt like kind of a difficult argument to me, like the idea that 2255H incorporates all of 2244B3 except for B3E is just a little weird, just on its face. Now, I get the argument that 2255H says, it's it's as provide, or it's referring to the certification process as provided in Section 2244, and arguably 2244b3e is not part of the process. It's like a consequence of the outcome of the process, that after the process is all said and done, if the certification is denied, you don't get to appeal that, to an en banc rehearing or to the Supreme Court or anything. So I get the argument. It seems like a permissible reading of the statute to me, but having read the dissent and the counter arguments, maybe not the best one. And now the majority says, like, okay, well, if it's permissible, then it, if there's two permissible readings of the statute anyway, doesn't satisfy this clear statement rule. Like, okay, I get that, but where does the clear statement rule come from? Because that seems even weaker. As I'm reading this, I'm like, okay, you say there's a clear statement rule, cool. Where? Why? How? And in the majority's, as I'm reading the majority's telling of the origin of this clear statement rule, I'm like, that feels like something you just kind of made up out of nowhere, even if it does come from the Supreme Court's jurisprudence, which the dissent makes a compelling case that it really doesn't. But even if it does, it's like, that still doesn't come from anywhere. There's no statutory text, there's no constitutional text. It's just, well, we had these practical and policy concerns with respect to this specific limitation on our certiorari jurisdiction, so we think Congress needs to speak more clearly. It's like, okay. And then how do you apply it? Like, what triggers this clear statement rule? Like, is it just, like, as the dissent argues, like, gerrymandered to this specific context? How clearly does Congress need to speak? The dissent argues this seems clear enough to me, but yeah, so that's probably the weakest major point of the majority's position. Although there was an even weaker point that I came across, or seemed even weaker to me, although not, arguably not a major point, that the the government and the dissent say, well, every court of appeals has read 2244b3e to prohibit rehearing these cases en banc in the courts of appeals, and the majority doesn't contest that. But that's part of the, that's part of the same provision that the certiorari bar comes from, and so that seems kind of weird. And the majority says, oh, well, just because it bars rehearing en banc doesn't mean that it bars certiorari, but it's in the same provision. Like, there's no structural, like, splitting that up in the statute or anything. It's not like B3E 1 and 2, where 1 is the rehearing bar and the other is the certiorari bar. No, it does it in the same sentence. In this, as the dissent says, in the same breath. So that's really that's difficult to accept. Now, maybe you just bite the bullet and say, it doesn't prohibit rehearing en banc for federal prisoners either. Every court of appeals on that score has been wrong. You could do that, and that would resolve this issue. Maybe a point against that interpretation, but I feel like that would be at least a little bit more honest. And I guess, sort of speaking of honesty, the dissent calling out Sotomayor for switching positions on this issue in in a different case, or in a different case brought by the same guy. Yeah, that that definitely stood out to me. It's a little funny that you've got the author of the majority opinion in this case adopting a position that she disclaimed in a prior case brought by the same guy. I also found it helpful that the dissent pointed out what it called the majority's quote mining of Castro. Because the majority says like, oh well, Castro, like, in trying to justify this clear statement rule, the majority says, well, Castro, says we really don't want to close our doors to this specific class of habeas petitions, and the dissent points out, no, Castro says we don't want to close our door to this specific class of habeas petitions while leaving them open to the government. The dissent says that's what Castro was concerned about, or the court in Castro was concerned about, and that's the outcome that the court in Castro was saying Congress should have to specify clearly, because you've got two similarly situated litigants, and Congress, according to the government, is saying you can file petitions for certiorari in this court if, you, the government, can do that if the certification request is accepted, but you, the federal prisoner, can't if it's denied. That's a kind of a concerning and funny result, and probably shouldn't come about without Congress saying so explicitly and clearly. And so when I read that in the dissent, I'm like, that feels a little dishonest there, Sotomayor, that like you kind of left out that part of what the court seemed concerned about in Castro. I don't know. Again, this is like the court, different justices on the court reading, prior Supreme Court decisions, and trying to extract, principles and legal holdings and whatnot from them, which I've said before is not easy to do in a consistent way. They're not always easy to do in a consistent way. It's very easy to read the same case for completely different, propositions. So, whatever. I guess speaking of the dissent, the one thing that I thought was kind of weak, or the one argument that I thought was kind of weak in the dissent, was the one about 2244 B3B and B3E, sort of like working together and requiring each other, and like if you don't apply E in a particular context, then it sort of like undermines B. I didn't find that all that compelling, because I don't know, the way I see it, B still does work. Like it does something if E doesn't apply. B tells you, at the very least, tells you where the certification process is supposed to start, or where the decision is supposed to start. It's supposed to start with a 3-judge panel of the appropriate court of appeals, and then E arguably tells you only what happens after that decision is made. So saying that E doesn't apply doesn't necessarily undermine B, at least not in whole. So that didn't strike me as all that compelling, but honestly, the rest of the opinion kind of did. The rest of the opinion, to me, pretty thoroughly undermined the majority's position. I found myself at the end of the majority's opinion thinking, yeah, I guess I can see it. I get the argument. I'm not quite sure, but I think I might side with the majority here. And then I read the dissent and I'm like, oh, never mind. Never mind. That's not nearly as strong as it felt. It is somewhat interesting. Something I forgot I wanted to point out. I didn't actually write this down, but that Barrett joined the dissent only as to part 1, but she didn't join the majority as to any part of its decision. So my guess is that that's not Barrett being like, I disagree with part 2, the analysis in part 2, because as to the merits of the claim, once we're past the jurisdictional question, like, can the court entertain this claim at all, pursuant to its certiorari jurisdiction? Once we're past that, Barrett doesn't say, I agree with the majority, seemingly. She just doesn't sign on to the dissent, and that strikes me as kind of that strikes me as Barrett just saying like, well, I agree with the jurisdictional analysis, so who cares about the merits? We can't get to them anyway. We don't need to issue an opinion on the merits, so I'm not going to sign on to an opinion about the merits. And that seems kind of characteristic of Barrett. And something that I would usually expect of Gorsuch as well, like Gorsuch and Barrett are both, at least in oral arguments, often focused on like trying to resolve the question narrowly. Like, do we really have to reach this issue, or can we leave it for another day? And here Gorsuch, doesn't take that course of action. He addresses the merits even though he thinks that the court has no jurisdiction to reach them. And I don't think that's improper or anything like that. Somebody in the dissent was going to address the merits almost certainly because the majority did. I don't think that it's a knock against Gorsuch that normally he wants to resolve only the questions that they have to, but here he addressed a question that the court technically didn't have to because, well, the court did address that question, so somebody had to, I guess didn't have to, but was almost certainly going to say something about it, so of course it's just writing a dissent anyway, he might as well. And then, again, Barrett, characteristic with her tendency to like Gorsuch, stick to only the questions that need to be answered. She just doesn't sign on to the dissent as to the question that doesn't need to be answered. And then I guess the last thing that I had about the dissent was I found it kind of funny that it addressed Jackson's lone concurrence in a footnote. I don't know that initially, like on first blush, it struck me as kind of a like, oh yeah, they're really not taking Jackson's concurrence seriously because they're just addressing it in a footnote, albeit a long footnote, but just a footnote. But I don't know. On second thought, it might just be like, well, it's a lone concurrence. We don't need to dedicate a whole it doesn't matter the merits of the concurrence or who wrote the concurrence. It's a lone concurrence. We don't really need to address it because it's not it's not part of the court's opinion, and only one justice signed on to it. So like nobody's gonna look at this and think, oh yeah, this is binding. This is super important. So yeah, it makes sense to dedicate a long footnote and not much more to it. But I don't know. I just thought it was kind of funny. As to Jackson's arguments, I agree with the dissent that concurrence was really weak. Like the dissent says, a denial is a denial, even if that denial is wrong. It doesn't matter if they follow the wrong legal process or don't go through the proper legal analysis. A denial is a denial, and B3E says a denial can't be the subject of a petition for a writ of certiori. It doesn't contain any exception for erroneous or, as Justice Jackson says, rogue denials. Now that maybe feels a little unjust, like, well, if the Court of Appeals got it wrong, didn't do the legal analysis, not only got it wrong, but didn't even do the legal analysis it was supposed to do, maybe even just went rogue and didn't even purport to. It just says, screw you. We don't want to certify your, your request or whatever. That feels pretty unjust, but that seems to be what the text of the statute requires. So, and maybe there's other avenues of attack against like rogue denials, again, as Jackson says, like denials that aren't even purporting to follow the legal framework, where, arguably the denial itself isn't the subject of the petition for writ of certiorari. And I guess speaking of a sort of like issue with, lack of justice or, unjust lack of recourse or whatever, this isn't strictly relevant to the legal question, but I did think why, the whole time reading the opinions in this case, I understand the impulse to want Bowe to have some sort of recourse, which he can't if the dissent is right. Like, unless unless the court accepts an original habeas petition from him, which, if I remember correctly, it had already denied previously, or if the Court of Appeals certifies a question of law to the court, which it didn't. Although Gorsuch says, hey, we could just tell the court that we would entertain such a certification. But yeah, Bowe having no recourse or very limited recourse, especially for for convictions carrying a 10-year sentence, that, as far as I can tell, everyone agrees, would not, would not carry those sentences today. So those sentences are arguably wrongful. It seems pretty unjust. And obviously he committed a severe crime and whatever, but that doesn't change the fact that he shouldn't be, he shouldn't be sentenced for, using a gun in connection with a crime of violence when everyone agrees, as far as we understand the law now, he didn't commit an act of violence or a crime of violence. So, at least not as the federal law, the relevant law, defines it. So, not relevant to the legal analysis, strictly speaking, but it is kind of hard to divorce from the legal analysis if you're like, yeah, this is an unjust result. And it's an unjust result that's entirely a product of the timing of his, of his first attempt at relief. But anyway, I think that's about all the thoughts that I had on this one. Yeah, definitely not a simple or straightforward case. Again, not for the least of reasons that the statutory scheme is not simple or straightforward. Not that it needs to be or should be or anything. It just, it makes it hard for laymen like me to follow and to think about in a clear way. But with that, if I may ask you, my friends on the other side of the screen, please like, share, comment, do all that. Follow the podcast wherever you follow podcasts, and if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. So, with that, tune in for the next episode where we will continue through the 2025 term opinions that have been recently released. So, until then.